Welcome to today's video. First, we will uncover why taking a quick tourist trip to the United States just before your F-1 student visa interview can put your entire study plan at risk. Next, we will break down the legal intent conflict, the timing issue, and the real consequences. Finally, we will give you a safe plan so you can protect your dreams and avoid irreversible mistakes. Here is our roadmap. First, we will explain why this topic matters. Then, we will cover the legal conflict of intent between visitor and student status. After that, we will discuss how timing creates red flags. We will then show the high risks and minimal benefits, followed by a safer plan of action. Next, we will bust a few myths, run through quick quizzes, and end with key takeaways and a disclaimer. This matters because a seemingly harmless short visit to the United States, right before your F-1 interview, can look like you are trying to set up for a longer stay. As a result, border officers and consular officers may question your intent. In turn, that can lead to denial, revocation of visitor authorization, or administrative delays that jeopardize your start date. Let's clarify the legal intent conflict. A visitor entry on ESTA or B2 is for tourism, business meetings, or short visits, nothing long-term. By contrast, an F-1 student visa is specifically for long-term study. Although both require non-immigrant intent, the primary purpose differs significantly. A visitor intends to leave soon, while a student intends to remain for the duration of their program. Consequently, if you enter as a visitor shortly before your student visa interview, officers may suspect you used visitor status to start preparing for studies or to establish ties. Therefore, your recent travel history is scrutinized for consistency. Any inconsistency can be deemed misrepresentation. Timing is everything. When a tourist trip occurs days or weeks before an F-1 interview, two red flags appear. First, at the border, officers may interpret frequent back-to-back travel as an attempt to use visitor status for purposes beyond tourism, which can lead to denial of entry or revocation of authorization. Second, at the consulate, the officer will see your recent entry and exit in their systems, and may conclude that your short trip related to preparing for study, such as scouting housing or meeting contacts, thereby undermining your prior claim of temporary visitor intent. The potential downside is severe while the upside is minimal. If an officer believes you misrepresented your purpose, that can lead to a refusal with lasting impact. Even without a misrepresentation finding, administrative processing delays or additional scrutiny can derail your start date. Conversely, the benefit of a short visit is negligible. Therefore, prioritizing your F-1 process and waiting to travel until you have the correct visa is the prudent choice. Here is a safer approach. First, if your F-1 interview is coming up, avoid any U.S. travel on visitor status. Second, strengthen your application. Ensure your I-20, financial proofs, and ties to your home country are clear and consistent. Third, keep your travel history simple and aligned with your stated purposes. Fourth, once your F-1 visa is issued and stamped, plan your travel accordingly. Finally, if your situation is complex, seek advice from a qualified immigration attorney. On one side, traveling before the interview can appear as an attempt to prepare for a longer stay, drawing scrutiny from both border and consular officers. This creates significant risk with minimal benefit. On the other side, waiting until the visa is issued aligns your stated purpose with your immigration status, thereby reducing the chance of negative outcomes and making your entry process more straightforward. This table ranks typical scenarios by risk. Short trips just before the interview are high to very high risk because they closely precede officer review and can be interpreted as preparatory steps for study. A long layover with a brief visit still creates a recent entry to explain. Trips taken months before the interview may be less risky but remain visible in your record. Traveling after the F-1 visa is issued is the lowest risk option because your status matches your purpose. Let's address common misconceptions. First, the idea that a quick tourist trip will not matter is inaccurate. Officers can see recent entries and evaluate them in context. Second, leaving the United States quickly does not remove the timing issue. The sequence still creates suspicion. Third, relying on anecdotes from friends ignores differences in individual histories and the fact that you often do not hear about refusals. The practical reality is that waiting for the F-1 visa before traveling remains the safest course. Quiz time. Which factor most increases suspicion for misusing visitor status before an F-1 interview? Option A, taking a single trip months before the interview. Option B, taking a short tourist trip 10 days before the interview. Option C, traveling after the F-1 visa is issued. Option D, not traveling at all. You may pause the video now to think about the answer. We will discuss the correct answer in the next section. The correct answer is B. Proximity amplifies suspicion. A short tourist trip 10 days before your interview is likely to concern both border and consular officers because it appears connected to your upcoming study plans rather than purely tourism. Second quiz. True or false? Leaving the United States quickly after a pre-interview tourist trip eliminates the risk of F-1 denial. You may pause the video now to consider your answer. We will reveal and explain the correct answer in the next section. The correct answer is false. A quick departure does not remove the timing issue. Officers still see your recent entry and may suspect you used visitor status for purposes related to your upcoming studies, which can lead to refusal or delays. These are the essential points. Visitor and student statuses impose different primary intents, so mixing them prompts scrutiny. Trips immediately before an interview are high risk with minimal benefit. The safest route is to wait for your F-1 visa and then travel accordingly. If your case is complex, consult a qualified immigration attorney. To conclude, prioritize your F-1 interview over any desire to visit the United States beforehand. Keep your travel history straightforward and consistent with your stated purposes. After your visa is issued, plan your travel with confidence. Finally, consider sharing this guidance with peers who might be contemplating a last-minute visit. Disclaimer. This content is for educational purposes only and does not constitute legal advice. Immigration rules and interpretations can change, and individual circumstances differ. You should consult a qualified immigration attorney for advice specific to your case, and verify requirements on official government websites. Thank you for watching. If you found this helpful, please like, share, and subscribe for more practical visa guidance. In the comments, tell us whether you will wait for your F-1 visa before traveling and what questions you want answered next.